Well, I know, but I don't think you've been fair with him. You want my honest opinion? I don't think you've been fair with him. You better make it 100% certain, 100% clear that you're not paying him. If you're going to have him do work, I don't care if it's on your girlfriend's, I don't care whose house it is, your friends, I don't care.
I turned myself in. I've been taking care of all my tickets, sir. I've been back and forth, getting all this squared away. We would have been done had this not happened with this public tax. I had to pay the money. And,
So you didn't really spend any time in jail in November?
yeah, I did the day. I did the day for this. I had a real bad seizure just a little bit ago, so you have to excuse me.
Take your time. It's okay. I'm just trying to figure out, it seemed like you were in custody in front of me.
Well, yeah, because I zoomed from QBH to show up for court. And you said you wanted to see me in person.
All right. Do you have anything to add, Ms. Wilds?
Your Honor, I think what you're asking, so on that new offense, that one was in front of Judge Hessen. He received 1 day of credit for that offense.
It seems like he was in front of me. I saw him a lot.
We've seen each other a lot this year, sir.
Yeah, he's been on probation since March. He absconded, Your Honor, and then he was in front of you. Got placed, not back on probation, but probation resumed. He was actually supposed to do his education program October 7th. He did provide a medical, so we were going to allow him to do that program in December. But he went out and he picked up this new offense, the disorderly that he's violated for. And right after that, he entered in at QBH.
All right. You said you can pay it right after the first of the year. You really don't mean by January 5th. You mean by when? February 1?
February 1st? Yes, sir. And yes. Yes, I need the month of February to pay. I need the month of January to get it paid.
You pay this in full by February 1. Judge Hessen presumably took care of whatever punishment was deserved on the other. I'm going to go ahead and let it go with that. Let's get your life back in order, though, Mr. Stefani. Okay, please? All right? And now, if you need more time, if you don't have the money, it's not a problem. Just call the court. We'll go on Zoom or walk in here on it before the due date. I'll give you an extension.
Judge, I wasn't aware that he was waiting on a tax refund to take care of this. We have March 1st instead of February 1st.
Well, he's got probation coming up when? Is that what you're going to do, is with your tax returns?
Well, that's what I was planning on.
All right, we'll do it March 1. You just got to diary that up, Ms. Wilds, because probation ends March 18th. So if we don't have it March 1, we're going to have to show cause them, okay? If you need more time, you call the court, we'll go on Zoom. All right? Or you can come in here on it before that due date, and I'll give you an extension. Good luck. Merry Christmas to you. Thank you. Stay out of trouble now, please.
That's it.
Thank you.
Thank you, Judge.
Thanks, Ms. Wilds. I think that's it for you, or you got another one?
Dylan Hall.
Dylan Hall, Dylan James Hall. 25D148-235 A and B.
Who would have Dylan Hall?
Sir, your name?
Dylan James Hall.
So he had a case taken under 7411 and HIDA, right? What did we do here? Let me see. You got a drug charge that was taken under 7411. You got a CCW charge taken under HIDA, and he was ordered to attend and complete the substances of abuse program, and they think he didn't complete it. How's he going to proceed on this?
Guilty.
Is that what you want to do, sir?
Yes, sir.
I'm gonna need Jessica on this. If you plead guilty, this would be your second violation, and you could get 10 days in jail. Do you understand that?
Yes, sir.
All right. Did you sign an advice of rights and read and understand the rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial. Do you understand that?
Yes, sir.
To the charge you failed to attend and complete the substances of abuse program, how do you plead?
Yes.
Did you fail to attend and complete that?
Yes, sir.
Anybody forced you to plead guilty?
No, sir.
Just give me 1 second. You did not attend, correct? Anybody force you to plead guilty?
Okay.
Why didn't you attend the program, sir? Can you tell me?
I did accidentally yesterday.
Accidentally missed it. Your name?
What's going on?
What do you want to tell me, Mr. Haynes?
That he needs to get the program done. I think it's an 8-week program. I don't know how much longer he's got on probation, but if he is going to need an extension, we'd ask the court to extend his probation on the.
July 30, you were ordered to do this. Why you been fooling around like this?
Got to get it done. I did,
Forgot to get it done.
He started the program at one point, then yesterday, so.
yeah.
What do you want to say?
Intake back in November 3rd, and then the next class didn't start until the following month, and that was when he then missed the follow-up. So he missed a follow-up for the weekly sessions on December 7th and then December 14th.
And how long is the program again?
The program's is 8 total sessions that he have to complete. So well, technically it's 9 altogether. It's an intake and then the 8 sessions. So he's completed 1 out of 9. And I don't know when their next session starts, because right now they're in one and they're not gonna let him join in now halfway through.
Probation, he's supposed to be here
Yeah.
for a review hearing January 14th. So I made a mistake on this one. Give me 1 second. Okay, he was placed on probation July 30, so he's scheduled to come off January 30. I'm gonna have to extend your probation for 3 months until April the 30 of 26. Pay additional costs of 75, additional probation fees of 60, serve 1 day on the court work program, and pay $35 for that. So you owe $170. We're gonna have to remove the review hearing date, Heather, so we're gonna have to make it closer to the latter part of April.
Okay, Judge, we have Brownstown, April 22nd.
That would be good. So the new review hearing date will be April 22nd at 9 o'clock, sir. April 22nd at 9 a.m., new review hearing date. So we're gonna give you that. And you're gonna go down the hall, pay your 175. Do you have that?
Yep.
Pay that and then go back and talk to Ms. O'Donnell about setting up your court work program day. You gotta stay on this. Good luck. Merry Christmas. Thank you. Thanks, Mr. Haynes. Thanks a lot. Take care. I think so. Man, what do you have here? What do you here on?
It's a temporary cell.
Oh, are they here? You're all set, I think, Mr. Haynes. Is Mr. Haynes all set to go? Heather, do you know if we got all these done? I think.
I do not have anybody on Zoom, so as long as everybody in person is done.
Still, looks like there are gonna be no shows, church and Davis.
What time were they scheduled? We'll put them on for warrants and, yeah, you can go.
Yeah, 9:15.
Yeah, we'll just issue warrants.
Yeah, I'll do them later.
You're all set. Merry Christmas to you, Mr. Haynes. Thank you as always for your help. Are you on that Spice? Are you Spicer?
Yeah.
I have Mr. Lochner in Zoom, Judge. I can let him in. I
Yeah,
wasn't
please.
aware who was in there, sorry.
John. You might need by with the motion on my desk. The trial briefing. Mr. Stevens is.
Oh, you didn't check, I didn't know who that
St.
was.
Louis, they're up at 10:30, so I need the motion on Spicer, which is on my desk. Trial brief on that, on the
Is that on your desk too?
St. Louis, yeah. Do I have Capital One versus Emily Burke?
I have plaintiff here. I don't have defendant yet.
Jeez. I don't even know what this is up for. Owner's Management versus Justice Spicer, 2502423. Come on up here, man. Mr. Lechner, your appearance?
Good morning, Your Honor. Attorney David Lechner, P number 67994 on behalf of Owners Management.
Hi,
Your name, ma'am?
Justice.
Mr.
All right. No, not yet, Miss, did you read her motion? Ms. Spicer's motion?
I read it, Your Honor, and before we get into it, I spoke with my clients. We're willing to withdraw our petition to reopen the case at this time and let Ms. Spicer finish out her probation. I do want to say that, just for the record, that she agreed to this probation and the probation said no violations of the lease. The lease doesn't allow for pets, whether it's her pet or I know her contention is that it was a visiting pet or she had a visitor who brought a dog over. That's still a violation of the lease. And a noise complaint, whether it's on Halloween or any other day, is still a noise complaint. So going forward, I want Ms. Spicer to be aware that although we're withdrawing it at this time, while she's on probation, any violation means any violation. But at this time, we'll withdraw our petition to reopen the case.
What was the basis by which you had indicated that she did not comply with the judgment?
There was a violation for an unauthorized pet, and there was a violation for a noise complaint noise violation late at night.
I know. Did you set those for hearing, or did you just file an affidavit of non-compliance?
I just filed an affidavit of non-compliance to reopen the case and waited for Ms. Spicer to file objections, which she did.
All right, so we're back to square one. You're withdrawing your petition to reopen the case. Your client has apparently accepted rent for December, right?
I don't know. I don't know that because we filed this back in November, so they might have put a hold on Ms. Spicer's ability to pay rent. Usually, that's their standard operating procedure when there's an action for eviction. They stop accepting rent. So I would defer to Ms. Spicer because my client's not here right now. I would ask Ms. Spicer if she was able to pay rent or not. If she wasn't, I will reach out to my client so that they open up the portal so that she can pay her December rent. We would not at this time be aggressing against her for failure to pay rent because if she didn't pay it, it was because she wasn't allowed to.
Right. She said in her response she already paid it for December. So are
Okay,
you satisfied? They're gonna withdraw their petition to reopen the case. Okay. So you are all set. Merry Christmas to you, ma'am.
Thank you, Your Honor.
Capital One versus Burke. 2502019. Mr. Saloom, your appearance.
Good morning, Your Honor. For the record, William Saloom, P41487, appearing on behalf of plaintiff.
Where is Ms. Umi? I saw her out there.
Yeah, I just spoke to her in the breakout room. Hopefully she's getting ready to join.
She should be coming back in. I just requested her to rejoin.
Okay.
Okay.
And we haven't been able to come to an agreement, Your Honor, so I guess we will need the court to make a determination.
I'm not even sure what you're here for.
That's a good point because technically, I guess we're here on her motion for a stay.
Judge, excuse me, counsel, if I may.
Yeah,
This was the one that we had received a motion from Ms. Burke requesting the court date moved up on her objection. The garnishment hearing, I believe it was. And
yeah,
we would ask that I move the date up.
Right.
Ma'am, your name, ma'am.
Ummi UMMIVIRK, Umi Work.
Your Honor, I think what happened is she filed a motion for installment payments scheduled for January 13th of 2026. We have no objection to that being heard today. I guess if we hear it today, then her motion for stay becomes a moot point. It's up to the court how the court wants to deal with the motion.
All right. So I'll just go ahead and hear your motion for installment payments now, ma'am, okay?
Yes.
Tell me why you can't afford this. I'm vaguely remembering what you're talking about, Jennifer, but not really. I remember you talking to me about how I wanted to proceed on this with regard to moving the date up. I vaguely remember that. What are you asking to be able to pay, ma'am?
My mom is not able to speak English well, so can I speak on her behalf?
Yeah, well, what is your name?
Marine Verk.
All right, so I got to be a little careful here now. I didn't know that, or we would have gotten an interpreter. I can't really let you, can you translate for me? I can do that so I can expedite the hearing. Can you speak to her and translate? I can't let you represent her.
Yeah.
All right, so your name is Marie Verk.
Marine Verk.
How do you spell your first name?
MEHREEN.
All right. And what language do you speak? You speak English, obviously. What does your mother speak?
Urdu.
And you also, are you fluent in Urdu?
Yeah.
Any objection to me doing it this way, Mr. Sloom?
No
I can't get an interpreter here this second.
No objection, Your Honor. I don't think it's a real complicated matter.
Right.
I'll let, no objection.
Ms. Burke, young lady, raise your right hand. You solemnly swear or affirm that you will make a true and accurate translation between the court and the parties here. In other words, you're going to translate to your mother, you're going to translate to me and the lawyer what your mother's saying. You promise to tell the truth and do that and make a proper translation under oath?
I do.
Okay. Now, all right, put your hand down. Now you're going to ask your mother, you're going to repeat exactly what I say to her, and you're going to repeat exactly what she says to me. You can't engage in a side conversation with her, okay? Fair enough?
Okay.
All right, ma'am, tell me
Yes,
how
sir.
much you think you can afford to pay. You're going to tell her that.
Okay.
I can
पुस्तक है अभी तू के लिए देने ने
I can afford at the most $20 a month.
How much?
$20 a month.
Do you
$20.
work? Wait a
Yeah.
minute, this isn't working. I thought you said she can't understand English and she's talking to me.
She can understand it, but not really well.
Well, I need you to translate for me, okay?
Okay.
Tell me why you can only afford, and you tell her this, tell me why you can only afford $20 per month.
अच्छा, क्योंकि मेरी minimum
तू मेनू गल क्यों नहीं करन देंदी तू ओनू 10 भी तू ओनू $20 per month क्यों सिर्फ दे सकनी है
क्योंकि मैं मिनिमम वेजेस तो कम करनी है तो मेरे एक्सपेंसेस बड़े ज्यादा हैं तो मैं सीखा मेरे लॉट ऑफ बिल्स ने मेडिकल बिल थेरेपी दे हेनरी फोर्ड हॉस्पिटल दे वेन मेट्रो हेल्थ दे इस वजह तो मेरा रेंट भी है.
Come on, you got to tell me now, please. Tell me.
She said that she can't afford it because she is working on minimum wage and because she has a lot of medical expenses and therapy expenses because of her shoulder rotated cuff is broken and she needs surgery for that. So she's been going to therapy and to the hospitals and appointments, and she has a lot of medical expenses.
Mr. Saloom, tell me what you're asking for. And I want you to go slow so this young lady can interpret.
Yes, Your Honor. So pursuant to the garnishments, we were receiving, I think, approximately $630 a month. But we would agree to accept $300 a month. We've tried to work out a payment plan with her, but haven't been able to do that.
She's only making $2,400 a month. she's got a motion here that says she pays $1,800 in rent and $600 in utilities.
I see. Yeah, Your Honor, I guess a more reasonable request would be $150 a month.
Well, I'm gonna make it $40 a month. Sorry. I'm gonna ask you to tell your mother, ma'am. Tell her, I'm gonna order that you pay $40 per month.
Oh, and the pay by 240 per month. The amount ka.
And I'm gonna ask you to prepare an order to that effect, Mr. Jerome, if you would, please.
Yeah, we will. There may be one in the file. I don't know. Well, maybe not. But in any case,
$40 per month beginning January 10th and the 10th of every month thereafter until paid in full.
There's something my mom wants to tell, and it's that she recently filed for a medical leave at her work where it wasn't covered, and she works part-time now, and it's hard for her to manage the expenses, so she wants to know if you can please go down. And she barely goes like 2 days a week now.
Jeez, I can't do much better. I'll make it 25 per month and I'll start it beginning February the 10th. And the 10th
Your Honor, if I may, this is approximately a $10,000 judgment.
I know.
And I appreciate her predicament, but whether it's 25 or 40, that's just, that's something people kind of work with, whether they're up or down as far as meeting their obligations. And, I think the court knows my position.
I get it, but that's my order. $25 a month starting February 10th. 25 a month starting February 10th. Now tell your mother they still can garnish. They still can garnish. Listen. They can still garnish they can't garnish wages, but they can garnish tax returns, bank accounts, and the like. So she needs to understand that. They still could garnish her tax returns. That's the best I can do. Tell her. Would you please tell her everything I'm saying?
Bank account the which the taxes less than it is up to best to
Can't do better than that. I'm sorry.
She wants to know if she can send the installments on her own.
Yeah, tell her where to send them, Mr. Saloon.
Yes, that's fine. We're going to send an order to the court for installment payments of $25 a month beginning February 10th, 2025. And we'll have a P.O. box and an address where she can mail the payments to us.
Tell her that. Tell her that.
On the bay o tenu address send kareda jite to on anu send karsuk niye.
That's it. Thank you both. Have a good day.
Thank you, Your Honor. Have a good day.
Thank you. Happy holidays, Mr.
Oh, Your Honor, one last thing. Is there, I don't know if there's a pending garnishment, or I know it was filed in October. It's some.
Is there a garnishment already filed in this?
Judge, I'm pulling up the garnishments right now.
If there is, I would just ask that anything being withheld be released to plaintiff's counsel.
Yes, there was one issued in September.
If anything's been withheld, tell her that on the garnishment, it's going to be sent to the plaintiff lawyer. On the garnishment.
The garnishment the which was withheld hoya the plaintiff lawyer no milnave. What does that mean?
It means if her wages have been garnished, then her employer's been keeping the money and they are going to send that to Mr. Saloon and the plaintiff's lawyer. Okay?
So she's not gonna get them?
No.
Okay.
No. Okay?
Your Honor, do you need us to do an order on the
all of that? All of that. The sooner the better, okay? Thank you.
Both. Thank
you.
Have a good day.
She wants to know if she can get the garnishments back.
No. Okay, I've been too fair. I haven't been fair with them, if anything. Have a good holiday, everybody. What's your name?
You as well, Judge. Thank you. Everyone have a good
What's
day.
that?
Davis.
Is that up for today?
11 o'clock.
You guys get how much is this case worth, Mr. Scanlon?
No change.
$1,000, Your Honor.
You guys can't resolve this?
The trial brief. Mr. Lewis doesn't have.
Mr. Lewis doesn't what?
Doesn't have a cause of action, Your Honor.
based part on the fact that my client has spent over $2,000 in material.
Come on up here, guys. Give me the file. I need the file. John, why don't you move all those? We're gonna have to have him sit there.
You should have,
Huh?
you should have that one.
I got this.
Should have.
Mount St. Louis versus Brian Marshall, 2502190R. Everybody, state their name.
It's not before Gerard Scanlon, P number 74992, appearing on behalf of the witness Brian Marshall, the president to my
Your
right.
name, sir?
Morning, Your Honor, Brian Marshall.
Mr. St. Louis, your name?
Donald St. Louis.
All right, let me just look back and file momentarily here. All right. All right. You know what? I hate this I'm filing. I just don't get it. I'm all for change if it makes it better, but it hasn't made it better. It's made it 4 times more complicated. So I don't have a small claims. This was initially filed in small claims, right?
That's correct, Your Honor.
Jennifer, have somebody bring me down the small claims affidavit. Before
pulling it
then,
up
I
right now.
had, before then I had files. It was a lot easier, but
Your Honor, if I may.
yeah, you can handle that.
Thank you.
All right, so I've got Mr. St. Louis claiming for labor performed. You're claiming 2789, right? Mr. St. Louis,
He returned my tools after
how much are you claiming?
just the 2,000 plus the court fine
$2,000. What's the $2,000 for?
wages for all the work performed,
Okay,
up to the point of where we had to move to another job because 2 weeks turned into 4 weeks and it wasn't anywhere because he wasn't.
all right, okay. Sit down, everybody. Give me your opening statement, Mr. St. Louis. You can tell me what your theory of the case is.
We were working on a job on Philly and Allen Park, Carlos, my partner and myself. For him. He wrote it up and doing the job. He approached us about his girlfriend, homeowner / Lauren. Wanted to have a bathroom redone. So, for the record, he's my stepson, you know. So I went when I met him at Lauren's house. And she went through the whole procedure of what she wants to do, that she do this, how she'd like to have it done. And I'm like, okay, so when it was all said and done, she went around in another part of the home to water plants, and he said, well, how much are you guys going to charge? I said to do all that work, except he was going to do all the tile work in the bathroom. She's fine. I said 4,800. We had a week to go still, and then when she went on vacation, because it was a 2-week vacation she was taking, I started. The first night, the first time in there, he was in there and I started helping him. And I asked him, I said, what are you doing? Are you taking away work from Carlos and I that you wanted us to do? And he goes, well, I'm just helping you get going. Don't worry, you're gonna get all the money. So I continued to go. Carlos would come when he was doing the skin work, the finishing muddy over on another job. So he'd go there for a couple hours, then come over and we'd work together. We completed demo of ripping out all the walls and everything.
All right, I just want to hear what your theory of the case is. He owes you money.
Right.
He owes you $2,000.
I'm being generous on that, Your Honor, because I'm only going, just being fair about for the amount of time and work I had to put in with him, including using my truck 2 times to go to Home Depot, meet him, load it up with cement, go back to her place, mix it, and all that. He just, for some reason, couldn't stay out of getting it so involved in this, and there was the problem. He was supposed to supply all the materials, we could have been in and out. But it didn't happen, so we put up with it to the point where the other job, Mr. Phillips in Dearborn Heights, had already, we backed him up 1 week, going into totally doing his whole remodeling on kitchen and everything. And finally we had to go 4 weeks. He wanted 2, so we got it done in 2. I said, yes. But at no point were we supposed to deal with him being involved with, he works for major contractor. He ain't even around during the day. And then twice on weekends he was gone. Once he took his daughter up north to visit the grandpa. Okay, that's fine. But we could not get the material to complete this job. So I figured.
It's a show paperwork. That's wise to be.
Good. I figured we normally figure out jobs out at $30 an hour labor. I got at least 80 hours, actually probably more, but I settled for 80. Carlos got 12 coming there. And that there would have been 24 on me and another 340 on him, something like that. So I just went down to 2. That was it.
All right, okay.
The only, but we don't track hours. We bid a job according to what the job is worth on the market. So that's why I said 4,800, but if I had to be reasonable, because they brought it up, wanting to know how many hours, well, we don't track hours, but if I had to give a rough guess, that's where I would put it. To, you know, about 20 some, just over 20, or pardon me, we are 80, about closer to 90 hours, 90. But I'll settle it. I mean, simple math.
So you're charging $100 an hour, basically?
No. $30 an hour times 80 hours. That's 2,400.
Okay.
And 12 hours for Carlos when he was there helping me with all as I submitted into your file, as you instructed to make sure I complete the thing for the court. There's pictures there, but that's not pictures of all the work that was done. I took pictures of a
All
lot.
right, okay. Let me hear from you.
Main premise of this cause of action, Your Honor, is that my client didn't supply the materials for the job.
Did.
Didn't. That's the main premise. Didn't supply the materials. That's what he said. When asked in an interrogatory to describe how the breach occurred, his answer was Brian failed to supply the materials for the job. And I've got receipts that show clearly that my client has spent over $2,000 in materials and he's prepared to testify with it. Further, I've also cited a case in my trial brief. This is the Van Dyke's case that indicates that when a job is done for a family member, which Mr. St. Louis has already testified that my client is the stepson, it's done for and gratuitously done and or furnished. In that there's a presumption that arises that Mr. St. Louis is going to have to overcome according to the case. He has no cause of action. He has no damages. My client supplied the materials, and thus we're asking that the case be dismissed and costs and attorney fees be awarded.
We did some work, though. Nobody's disputing you did work, are they?
That's not the nature of the breach. The nature of the breach is, according to him, in his own words, in the interrogatories that I'm going to introduce as evidence, the nature of the breach is that he failed to supply the materials. My client has received from Home Depot indicating that the materials were purchased and he's prepared to testify that he did purchase them.
All right.
Therefore, he has no cause of action.
Call your first witness. Call your first witness. If you want to testify, you can come up here. If you don't, you can call your friend here, or you can call the defendant here, or call whoever you want. But you got to come up and I'm going to swear you to an oath. That was just an opening statement before. Yep. Raise your right hand. You solemnly swear to affirm it. The penalties of perjury. With the testimony you give in these proceedings will be the whole truth self you got. Have a seat. All right, go ahead and tell me. Now you can be detailed. Go ahead. Tell me everything you want to tell me.
When I went in there, they had already been doing shopping. A toilet somewhere, it was worth
Are
$1,000,
you charging for the labor or for the materials?
just the labor. The agreement was he's gonna supply the material when I needed it, not purchasing a cabinet here, a toilet that was all done before we even started. I didn't even went in. They had stuff stockpiling. So if this material for receipts is where he's going, the only materials he bought while I was there working was copper, piping, fittings, shut-offs, the PVC 3-inch, 2-inch, and 1.5 for the drain systems. There was some lumber.
Sir, I'm asking you, are you suing for labor or materials or a combination thereof?
Just labor, sir, Your Honor.
Just labor.
Here, that's all, Your Honor.
All right. And how many hours labor did you have?
I'm saying, I can safely say I put in at minimum 20 hours labor. We charge $30 an hour labor. That's a very good rate in this kind of.
Okay, that's $600. How are you coming up with 2,000?
80 hours.
You said 20 hours.
Oh, I'm sorry. I'm wrong. 80 hours, 2 weeks. I was there for over a 4-week stretch, in the evening and on weekends.
And what did you do in that 80 hours?
We finished
I'm sorry?
demoing all the old walls and everything. Then I had to remove piping. And there was 2 exterior walls when come in. I ended up removing them. Copper, then I was doing rerouting copper for where it was supposed to go, the whole drain system. He cut the floor out because he was.
I want to know what you did. Don't talk about him.
Yeah.
What else?
Then I was there in the evenings helping him. Like I said.
What were you doing?
People got cement, come back, mixing cement. He took it in and doing that.
What else?
The wire, couldn't move all of it. Some
Demoed the walls, removed the piping,
repair and.
rerouted the carpet, and you went over and got cement for him. That take 80 hours to do all that?
Oh, yes.
80 hours to do all that?
Yes, you're right.
Okay, what else? Anything else?
Because there,
I just want to know what else you did.
there's a lot.
I want to know. Tell me.
So the walls that I removed were the existing old walls. Okay, and then I chipped around to give him an idea of where the plumbing had to run. I had to retake apart. This is it. Even going to do stuff in the evening. And then the next day I gotta clean up when
I want to know what you did. Just tell me what you did. I don't want to know what he did. I want to know what you did.
And I loaded the trailer and hauled it to the dump, emptied it and brought it back, which I even paid the dumping fee. Which that was out of my own pocket. So all this work that I put in time putting in on this job. And many other times it was cleanup after him leaving a mess all over. That was it.
And he tell you he was going to pay you $30 an hour?
No, he agreed to pay 48 for the job, but we were
48 what?
$4,800 for the whole job. Then.
But you never got that in writing?
No, we had a verbal agreement and when he even discussed it with, talked to Carl about working over there too.
All right, go ahead.
So basically, we're just asking for the amount of work we did came to almost half of the work that was supposed to be put in, not counting tiles.
All right.
That was his understanding and agreement.
Okay, fair enough. You got questions for him, Mr. Scanlon?
You. Mr. St. Louis, you indicated that you don't have anything to prove that this conversation between you and my client took place, correct? Regarding
At the house or at the Fillmore?
you don't have any proof regarding the conversation that took place that indicated that my client was going to pay you $4,800 for this job. Nothing in writing.
Nothing in writing, no.
Okay, and you indicated that you don't have anything in writing to prove that my client offered to pay you $30 an hour for labor performed on this job?
No, he wanted the ballpark price for the job, which I quoted 4,800.
Your Honor, can I approach the witness?
Yes. Had you worked with your stepson on work before?
Yes, we were coming off, back there, we were coming off of a house in Allen Park, Philomene. We opened up the kitchen, removed walls, redone it. I moved, electrical, plumbing. Actually, I did a lot of electrical for it. But we had no written agreement. It was a verbal agreement on that one too, which.
All right, okay. I just asked you if you'd worked with him before. That's good. You answered the question. You can proceed.
I'm gonna approach the witness, Your Honor, and show him what's been marked as proposed exhibit, defense proposed exhibit. Sorry. Sir, do you recognize that document?
Did you just mark that yourself?
I did, unless you're a sticker.
Yeah, we're gonna mark it defense one. Hand that back to my recorder, will you, Mr. Scanlon, please?
Defense one?
Yes.
Thank you. Recognize that document, sir?
Whole thing?
Yeah, I'll give you some time to look through it. Question. We have any local officials?
I'm reading, it was more about supplying material. He kept,
I didn't hear a word you said, sir.
I'm sorry, there's no question. I just asked if you recognize the document, sir, yes or no?
yes, I did.
Okay, how do you recognize that document?
Well, you sent it to me.
Okay, and these are interrogatories that were sent to you by my firm? I'd like to draw your attention. Question number 5. You can turn to that one, please.
Yeah, I got it right there.
Says, please describe in detail how the verbal agreement between you and the defendant was breached. Can you read for me your answer, please?
Brian failed to supply all material for us and continued to disrupt the work that Carlos and myself agreed to do from the agreement we made.
So that answer indicates that my client, the breach of the contract occurred because my client failed to supply the material, does it not?
Well, there was more than just that.
So yes or no questions, sir?
That was part of it.
Well,
Yes
yeah,
or no?
that was the answer you gave though, right?
Yes.
Okay.
Well, there you have it.
I know. What else, Mr. Scanlon? I think this is pretty easy. I want to hear from your client.
Understood, Your Honor. I just want to put the proofs on the.
All right, go ahead. Ask me your next question.
Question number 5. I'm going to ask you to produce a copy of any invoice that you sent to my client for any analysis. You didn't send him any outstanding invoices, did you, sir?
No, I wasn't buying anything.
All right. But you never sent him any outstanding balances for any materials, and you never sent him any outstanding balances for the labor work, right? Yes or no?
There is no balance for material. I was not responsible for purchasing it. So why would I send it?
It's not a question.
I don't need you to argue with him, but I got his answer. Move on to your next question.
And you indicated, sir, that Mr. Marshall is your stepson?
That's correct.
I have nothing further for this witness at this time, Your Honor.
You have any other testimony you want to offer? Yes or no? No. Okay, I want to hear from Mr. Marshall. Come on up here, Mr. Marshall.
Derek, I moved to admit this.
Yeah, you can move to admit that. That's defense one, right?
That's defense was even.
Any objection to the admission of that, Mr.
No, Your Honor.
Defense one is admitted. Mr. Marshall, come on up here. Raise your right hand. You solemnly swear affirm under penalties of perjury, the testimony you give in these proceedings will be the whole true self you got. Have a seat.
Your Honor.
Wait,
I do believe that what he just admitted, I already gave you a copy in the file.
it's fine. It's fine. Did you hire him to do some work for you?
I did request for, if they'd be willing
I
to.
can't hear you. Keep your voice up. Did you hire your stepfather to do work for you?
I requested assistance for him.
Did you pay him?
I did not pay him. He was under he was gonna help me with my girlfriend's bathroom.
Did you pay him on the prior job that he had just described that he helped you with?
I did, Your Honor. That was through my construction company.
But you didn't pay him on this one?
Correct.
Did you ever stop him from going over there?
I would never stop him going over.
Did you ever tell him, I'm not paying you for this?
I mentioned it on a text message when he called and said I owed him money for work he performed. I told him that I was gonna, it was the, if I may, Your Honor, the bathroom was for my girlfriend. It was boyfriend helping girlfriend.
No, it wasn't. It was your girlfriend, not his.
Right, not his girlfriend.
Right? Wait, wait. I want to ask you some questions here, and I get it. Do you have any reason to dispute that he worked on that bathroom?
No.
You heard how many hours he said he worked. He said he worked 80 hours. Do you have any reason to dispute that?
That no.
How many hours do you think he spent working over there?
Realistic work is probably 10.
10 hours?
10, if you, I would give him 20.
Did he demo the walls?
I assisted in demoing, yeah.
I didn't ask you that.
Yes.
Did he demo the walls? Did he remove the pipe?
Yes.
Did he reroute the copper?
No.
Did he go and get supplies from time to time?
He assisted me getting
He got cement, right?
in his truck with my.
And he brought it back there, right?
Correct.
And was your girlfriend home the whole time?
No.
Were you there every time that he was working there? How did he gain access if you weren't there and the girlfriend wasn't there?
He had a key provided by my girlfriend.
Is $30 an hour a normal price for that work?
Yeah, that's a fair price.
But you expected him to give it to you, do this work for free?
It was a team effort. Carlos was gonna be the gentleman who came in and did.
I know, but he wasn't the girlfriend, right? I mean, you were doing this for your girlfriend, right?
Correct.
Was he friends with your girlfriend?
Yes,
Was he friends with your girlfriend before he started working on the job?
yes. He's known her for a long time.
How long's a long time?
And my girlfriend and I have been together for 8 years.
How sad. You guys are father-in-law and, stepfather and stepson, and you guys are in here and,
I agree.
huh?
I agree.
Well, I know, but I don't think you've been fair with him. You want my honest opinion? I don't think you've been fair with him. You better make it 100% certain, 100% clear that you're not paying him. If you're going to have him do work, I don't care if it's on your girlfriend's, I don't care whose house it is, your friends, I don't care. Do you have any questions of him?
Mr. Marshall, you indicated that the amount of work that was done by Mr. Hussein was amounted to maybe 20 hours. Correct. Not the 80 that he's indicated. Correct. And you did in fact pay for labor or materials rather, from Home Depot.
That's right.
Okay. And you had those on your credit card statements?
Correct. The Home Depot credit card statements.
No, very close to witness.
Yeah, sure. I don't care what he answered on the interrogatories. But did he say or not say that he wasn't seeking any amounts for materials?
It's the basis of his lawsuit.
Well, I don't think so. It sounds to me like it's more labor. Are you not suing for the labor?
Labor only, Your Honor, time put in. For work done.
Even his affidavit, money's owing for labor performed at 23776 Carter Road, Brownstown.
Right.
I don't care what he said in an interrogatory. He's not a lawyer. He did a half-hazard job. I'm not even considering materials here. I'm not awarding him anything for materials. So I don't think we got to talk about materials because it's not relevant. Unless we get into the 4,800 and you want to start talking about that. 4,800 included materials, and so this guy, Mr. Marshall, bought some of the materials, so that should rightfully come off the contract price. But I'm just telling you how I'm leaning here, and that is this guy's entitled to quantum Merowith. Whether they had a ironclad solid agreement or not, $30 in the industry is not outrageous. He clearly did some work. The question is how much work, and it has nothing to do with the materials. But go ahead, you ask, and I'll rule, and I'll stop you if I think you're going off into places that are.
Well, and I would argue, Your Honor, too, that he answered these interrogatories and indicated that the breach occurred because materials weren't paid for. Regardless of
The
whether.
first word of his claim is for labor performed.
Right.
Look at his affidavit and claim.
So what's the basis?
Hang on, I want you to look at his affidavit.
I did. What's his basis?
He said money's owing for labor performed. Why are you arguing with? I mean, that you got it. I could read this when I was 6. Money's owing for labor performed. He doesn't say anything about repairs. I'm sorry, it doesn't say anything about materials.
So he's indicating that there's labor, yet when he answers the interrogatory.
I know. I get it. That can go to his credibility. I get it. But that's what his claim's for. And I heard everything you said, that he indicated that this gentleman didn't supply him with the materials. I get it. But I don't think he's really talked about materials. He talked about picking up materials maybe that Mr. Marshall should have picked up. Go ahead, ask your next question.
No, that's fine. I'll rest.
No, I don't, listen, I'm not trying to talk. This is a very small case. And I want to afford you every opportunity to ask whatever you want. I'm just telling you where I'm going with that. And that's what I'm going to do on these little cases. That's what I always do. And so we don't have to guess. This isn't over 25,000 or anything more. But go ahead. Let's. All right. Do you have any questions of him?
I do, Your Honor.
Go ahead.
Finished on that Sunday. And you stormed out because you wanted to run wiring, and I'm like, upset of you. Now, after that day, I called you. And I said, I need the rest of my tools.
Is this a question or a testimony?
I wanted to verify that this is what I asked you for money owing. What was your response to that?
You asked if I had your planner.
No, about the money. When I said you owe me $2,000, what was your response?
I don't know you when you walked off the job.
You said you don't have to pay me because we didn't have a written contract. Is that correct?
I don't know. Exactly. I gave her a text message, so.
When I told you that night how much money that Carlos and I would expect to do everything, and you were only gonna handle tile work at the end, did you inform Lauren about that?
Lauren was present during the conversation.
She was not present when I told you the amount of money. There was only you and I.
All right, you can't argue with him.
Yes.
You can come back up on rebuttal and tell me something different, but you can't argue with him. He's not giving you the answer you want.
Did the homeowner know that the amount of money we wanted?
Lauren was present there.
Chad calls for speculation.
That's fair. I'm gonna sustain. Strike that answer. Go ahead and ask your next question.
That's it.
You can step down, sir, unless you have something else. Come on back. I want to hear from you. Is this your buddy here?
This is Carlos Velazquez. Him and I have been teamed up for 27 years working together.
Come on up here. Can you spell your name for my recorder?
E as in Victor, ELASQUUEZ.
Raise your right hand. You solemnly swear or affirm under penalties of perjury, the testimony you give in these proceedings will be the whole true self you got. Have a seat. You know which residents they're talking about.
What's that?
You know which residents they're talking about.
48 minutes. That's the city that Brian's girlfriend lives in.
Did you do work there?
Yes.
How much work did you do?
Help around doing the plumbing.
I didn't ask you that. How much work? How many hours? What did you do?
I assisted Brian with plumbing and doing a couple framings and walls. Right by the back side of the shower. I was at another job, in between jobs, and while I was letting stuff dry over there, I would come and help Ron a little bit. That's how we work. So he would do the plumbing, electrical to get started, then I would come over there, then we would do the drywall. I would finish all the drywall, then we will assemble everything, because it's a step-by-step process, doing things like that.
Do you have any questions of him?
No, Your Honor.
Do you have any questions of him?
Well, how much time did you spend on this job?
About 14 hours.
That's it?
Yes. We was in the middle of another job. I was finishing the other job.
Were you there?
Process, I would go over and help him with a few things.
Were you there the entire time that Mr. St. Louis was there?
I was not.
So you have no way of saying how many hours Mr. St. Louis spent on this job?
The way the job works, it's not,
Yes, sir.
like a small puzzle.
Right.
So, no, I wasn't there the full time.
So you don't have any idea how many hours Mr. St. Louis?
Just basically from when he told me every single day call.
Okay, thank you.
I'm sorry, I didn't hear that.
Basically, every day he would call me. And he would tell me, what he did. It just,
Any other questions of him? Either one of you?
All right.
You can step down, sir. Thank you.
Thank you.
Do you have any other witnesses, Mr. St. Louis?
No, Your Honor.
Do you have any witnesses, Mr. Scanlon?
No, Your Honor.
Any argument, Mr. St. Louis?
I don't know if Your Honor has had a chance to look at all the pictures that I put in the file for the court when I filed it here, the response from his attorney.
I don't look at photographs and documents like that unless they're admitted into evidence. Is there something you wanted to admit into evidence that you wanted me to look at?
I'd use, enter all these as evidence,
What are those?
pictures of work that was performed.
How many pictures you have?
Oh,
How many? More than 5?
well, yes, more than 20.
I mean, I can have them marked if you want. Mr. Scanlon, any objection to me just marking all of those pictures as plaintiffs in one? You gotta lay a foundation. I mean,
There's no foundation for them and they weren't produced prior to, the court had a scheduling order on this case. He was supposed to produce those prior to, he didn't. So I would completely object to that. It's inappropriate.
Your Honor, that form that he showed you with all the questions that I answered, I also turned in an envelope inside that vanilla that had pictures exactly of what you have here. Was turned in at his.
all right. Okay. Give me the pictures. Hand up the pictures. How many pictures you got? 20? Why don't I
Oh, do I give it to you, sir?
oh, you tell me how many pictures you have there. Let me see. Mr. Scanlon, I could let him come back up here. I mean, what's fair is fair.
I'm sorry, who you're on?
I'm gonna just have these marked 1. You saw all these pictures, right?
No, I have not.
You've not seen these?
No.
There's roughly 20 pictures here.
Because you don't have it, it's in the.
I'll let you take a look at these. And my inclination is to have the first picture marked plaintiff's 1. Mark outside on an envelope plaintiff's 1 and put all these pictures in here. Take a look at those. You're still under oath a second here. Do these pictures demonstrate all the work you performed at this residence?
No, they do not, there is some in there where early pictures of where I was rerouting copper, and then I should have taken pictures at the last day of finished copper run.
But all the pictures there, do they reflect work that you yourself did personally?
They do, Your Honor, except the removal of the concrete.
Do you want to have me mark those?
No, not at all. I don't even know. He just not established a foundation for that.
Man, okay, hand them back. I'm not gonna admit those. I'm gonna listen to you both argue. Tell me, what would you like to say?
Pardon me, Your Honor.
I'm gonna have you guys argue your closing arguments. Nobody else has any witnesses, right, Mr. Scanlon? Mr. Scanlon, you don't have any other witnesses, right?
No, I don't.
Go ahead.
I have no other witnesses either, Your Honor.
I know, I want to hear what argument. You want to make an argument? You don't have to.
No, other than the fact that the work was performed, his evaluation of, I can understand why he wants to lowball hours, but just on the cement work for 2 times this, 10 hours of my time there.
Okay. What do you
so-
have to say, Mr. Scanlon?
Burden of proof is on the plaintiff, Your Honor, to prove his case. He has the burden to produce evidence to show the court, to show the court how many hours he's actually worked. We have no testimony from any witness that would reflect that he actually performed 80 hours of work on this property. His own friend, Carlos, didn't even testify that he was there with him at the time that the job was being performed. So he couldn't even verify how many hours were actually performed on this particular property. This was an unfortunate job, where, you have 2 individuals, a stepson and a stepfather, that are fighting over a verbal agreement. No evidence of the agreement, no evidence of anything in writing, no evidence that my client indicated that he was going to pay him. I ask that this case be dismissed.
Thank you. Anything else, Mr. St. Louis?
Yes, Your Honor, if there is no agreement, why would he tell me on the phone when I had a request payment, he didn't have to pay me because we didn't.
I don't want to hear anymore.
No.
I don't want to hear anymore.
Yeah.
If you were not going to pay him, it was incumbent upon you, Mr. Marshall, to fully and completely let him know that. Especially if you'd come off another job. This wasn't like you went to him. I heard no testimony. You went to him and said, hey, listen, Susie or whatever her name is, we've been going out 8 years. We're all close. I'd appreciate it if you do me a break on this, give me a break on this and help her out and not charge her or not charge her through me or make me eat the price of this because you're helping me. And I've got to pay you. I heard nothing like that. And I got to tell you, whether I admitted those pictures or not, based on what he told me, and I'm no construction guy, sounds like a lot of work. I have no reason to disbelieve his testimony. Judgment for plaintiff, $2,000 plus the 88 filing fee. And if you have any other fees, you have a motion fee, I believe $20, maybe not. What other judgment or fees does he have here, Jen? You have any other out of court?
Judge, I think that's it.
I think that might be defendant's motion filing fee.
It was defendant's motion.
Yes, so I'm gonna make it 2,088. Can you pay this today, sir? When can you pay this? Okay. If there's a way you can go get it today and write him a check, I can do a stipulated dismissal. If you can't, I have to do a judgment.
I can get a check.
Today,
I can make it happen.
can you get it here in the next half an hour? Yeah, you good with coming back in an hour?
I am here.
The quicker the better. Mr. Scanlon, will you prepare a stipulated order for dismissal with prejudice? And then once I'm gonna wait here. I'm not gonna go anywhere. And my staff's not gonna be able to go anywhere. So I'm gonna ask you to go hustle on this and we'll go from there, okay? And then we'll do a stipulated order to dismiss with prejudice once he tenders the check. Okay, thank you. All right, what do I have with you, Mr. Collis?
That's
Your
Ms.
Honor, you
Davis's
have that
case.
motion to reinstate that last week, Ms. Davis couldn't hear us, even though we were talking and she was
Health
supposed to come
versus
in.
Wanda Davis, 2404457.
Good morning, Your Honor. For the record, Stuart Collis on behalf of the plaintiff in this matter.
All right, ma'am, your name? So this gentleman was here, you were here, and you couldn't hear us last week, so we adjourned it. He asked me to reinstate the case. It got dismissed for no progress, right, Mr. Collis?
That's my understanding, Your Honor.
All right, so what I'm gonna do is, Jennifer, is that what happened here?
I'm looking, yes, dismissed for lack of progress, Your Honor.
So I'm gonna reinstate the case. Motion to reinstate is granted. And then I'm gonna give you, ma'am, I'm gonna give you 21 days to answer the complaint. So motion reinstate case granted, defendant to be served with copy of order reinstating case, and copy of summons and complaint to be sent to her last known address. Where do you live now, ma'am?
18758 Van Horn Road,
187 what?
58
58?
Van Horn 2, 1 Michigan 452.
Where is that? Bristol Hills or what? Okay. So you prepare the order, you send it to her, she'll have 21 days to answer.
Yes,
And
sir.
then-
I'll prepare that order and e-file that
Ma'am,
immediately.
if you don't have a defense to the case, I would just suggest that you just get with Mr. Collis, he's a reasonable man, and set up a payment plan.
That's what I want to do.
So maybe you can call him in the next day or so, and then try to resolve it.
Sounds like a plan.
Okay, so send me that order and you guys talk and see if you can resolve it, okay?
Absolutely, Your Honor.
Thank you
Have
very
great
much.
holidays.
You too. Happy holidays to you, Mr. Collis. Thank you.
Thank you very much. Hope you have a great New Year too.
Thank you. You too. Do I have Vicky Assenmacher here on this one, Jennifer?
Judge, that was the last one I had was for Davis.
I don't know why Vicky Assenmacher. Maybe this is the one where I denied the motion.
You know what? I think we got some sort of documents in on that. So if you had your copies, that might.
We're done. Thank you. Thank you.
This courtroom hearing starts with a young defendant already on thin ice with the court, and within minutes, the judge realizes the situation may be getting worse. The man is accused of violating probation after failing to complete mandatory drug and alcohol testing, something the judge says has already happened multiple times before. At first, the defendant tries explaining that he recently started working late shifts at a restaurant and kept forgetting to call in for testing because of his exhausting schedule. He says he was waking up at 5 a.m., getting home near midnight, and struggling to keep track of everything. But the judge clearly isn't buying the excuses. What do you mean you didn't know you had the test? The courtroom suddenly becomes tense. The judge starts listing previous missed tests one after another. August 30th, August 31st, September 1st, making it obvious this isn't the first problem. Then things get even worse when the court discovers the defendant was also about to leave for a vacation trip to Florida, despite all the probation violations already stacking up. You're not going to probably go out of town now. The defendant looks nervous as the judge reminds him the court already showed him leniency before. And now, after missing tests again, the judge's patience is almost gone. Then comes the line that changes the entire hearing. "My patience is running thin with you." The courtroom goes quiet instantly. At that moment, everyone realizes the defendant is dangerously close to losing his freedom completely. One more mistake could mean jail time, probation revocation, or even harsher penalties moving forward. Still, instead of immediately locking him up,